I can't stress enough the importance of hiring the right people with the right qualifications and the right licenses. Since the killing of United Healthcare CEO Brian Thompson, I've been seeing a growing trend in executive protection hiring. Corporations actively seeking retired law enforcement officers specifically because they are covered under LEOSA for nationwide concealed carry authority. On the surface, that sounds like a smart risk decision. In reality, it often creates a false sense of compliance and a false sense of security. LEOSA, the Law Enforcement Officer Safety Act, addresses firearms carry authority for qualified individuals. It does not replace or satisfy state licensing requirements for executive protection or security operations. Those are two completely different legal frameworks. In many states, providing executive protection services, whether armed or unarmed, requires proper agency licensing, registration, and regulatory compliance. Hiring a retired officer with LEOSA credentials does not shield a corporation or contractor from liability if the protection work itself is being conducted without the required state authorization. Here's what I'm seeing in the field right now. Companies assuming LEOSA equals operational compliance, protection roles being filled without verifying state licensing requirements, contractors being engaged without proper agency credentials, and as a result, real exposure to civil and regulatory liability. Let's take Florida as an example, my home state. To engage in executive protection work, you need to be properly licensed. That typically means either a D license for security or a C license as a private investigator. If you're going to be armed, you also need a G license. And here's the part a lot of people miss. According to the Florida Department of Agriculture and Consumer Services, and supported by the Florida Association of Licensed Investigators, LEOSA does not satisfy the requirement to carry a firearm while working in a professional capacity. Neither does constitutional carry. On top of that, you can't freelance this work. You must be operating under a licensed agency, what Florida calls an A license. Now, if you think Florida is strict, look at Virginia. Virginia regulates executive protection under the Department of Criminal Justice Services, DCJS. If you're performing close protection there, you fall under the Personal Protection Specialist, PPS designation. That requires state-approved training, registration with DCJS, background checks, ongoing compliance, and renewal. And if you're armed, that's another layer of certification. So again, LEOSA may allow you to carry a firearm, but it does not authorize you to operate as an executive protection professional in Virginia. Those are two completely separate requirements. This is the mistake I'm seeing over and over again. Companies are confusing firearms authority with business authorization. They're not the same thing, and getting that wrong creates real liability for the company and for the individual. Coming from the federal side, this isn't new. We always operated inside clearly defined legal frameworks. What's new is seeing the private sector try to replicate executive protection without fully understanding the regulatory side of it. If a program can't withstand regulatory scrutiny, it won't withstand legal scrutiny either. And that's where companies are exposing themselves, not because they didn't hire capable people, but because they didn't hire compliant ones. Organizations should be asking themselves, are we properly licensed in every state where services are being delivered? Is our protection provider operating under a compliant structure? Are we separating firearms authority from business authorization? Because if you're not asking those questions, you're not running an executive protection program. You're taking a liability. Capability without compliance is a liability multiplier. If you like this content, please like and subscribe to my channel, Applied Tradecraft and Technology.